Welcome to the Supreme Court of the United Kingdom. We are hearing today the appeal of KE Entertainments against Her Majesty's Revenue and Customs. We are present being addressed by counsel for the appellant, Mr. Kodara, Queen's Counsel, and I'll now invite Mr. Kodara to continue with his submissions.
My Lord, I'm most grateful. My Lord, I've completed my citation of Elida Gibbs, hopefully to demonstrate that Articles 73 and 90 of the PVD should be viewed as a unity functioning together. And it is now common ground that the word consideration, wherever appearing, means consideration in the VAT sense. My Lord, in that same vein, albeit more briefly, may I refer to Finance Amt Bingen Alze. That is in the bundle, the most recent bundle to come to your lordships. That may be yesterday or this morning even. It is, I have a page number of 1810, but that might not be relevant.
Yes.
It is a 2017 European Court case. Is it convenient for me?
Yes, we have the case, thank you.
I'm grateful. This was a case, very, very briefly, this was the case to do with the supply of medicines, one into the public and the other into the private sector. There was a debate as to how, if at all, to deal with rebates and discounts. So factually, it's very, very far from our case. However, the court did touch upon the issue that, or an aspect of the issue that concerns your lordships. If I could ask the court to turn to page 1832, if you have that numbering, if not, to paragraph 45 of the decision of the European Court. The issue that was being considered was what's the right approach to post-sale discounts that were offered to both the public and the private sectors in Germany. Ultimately, it was the private sector that was litigating, and that brought the court into the sphere of what your lordships are looking at. And this case might just be seen as further underlining what is agreed to have been an erroneous view as to the meaning of the word price or consideration, taken with great respect by the Inner House, and I've already mentioned it. At para 45, the court says this, it's the bottom of a page I have numbered at 1832. As the Advocate General observed in point 42 of his opinion, even though in that judgment the court's analysis concerned interpretation of Article 73 of the VAT Directive, the interpretation that the judgment provided of the notion of consideration laid down in that provision may apply in respect of the words where the price is reduced, used in Article 90 of the directive. So that, given that both that provision and Article 73 of the directive address the components of the taxable amount. So pausing there, your lordships have that now to assist them in their consideration of the interaction between the language of Article 73 and 90. They go, just to note, paras 43 and 44, which preceded it, this is a reference to one of the gaming cases, not one to which I'm going to refer because it doesn't really add anything to what we've seen. That's the international bingo case. And the other observation, just to note, is that going back a page to 1830 and to paragraphs 31 to 33 of the judgment, there are some general statements, in particular para 32, speaking of Article 90, the court said halfway down that paragraph, that provision embodies one of the fundamental principles of the VAT Directive, according to which the taxable amount is the consideration actually received, and the corollary of which is that the tax authorities may not collect an amount of VAT exceeding the tax which the taxable person received. And that bears reminding ourselves that what we are actually debating is how much of the money that the punters hand over my clients are to be taken to have actually received. Of course, in commercial terms, they will set, no doubt, all the payouts throughout the year against all the income and receive a net figure. For the purposes of VAT, we are focusing on whether on the world of the session or indeed the individual games, and those are the four corners of the current debate. But to draw the line around those is already quite favourable, I would submit, to the commissioners, and indeed bingo duty now has a 5-week period. Within this case, before I leave it, your Lordship saw a reference to paragraph 42 of the Advocate General's opinion, and that appears at page 1817, where he refers to the unity of Articles 73 and 90. So no more needed from me there, but that just underlines the overall unity of the Article 73 and Article 90 system. I move on. I'm very mindful of time, my lords, and therefore I will try and be as concise as I can. There's a trilogy of cases where this methodology is applied. I will take them briefly. They're well treated in the case, and indeed they are not that much an issue. I refer to Glover, Spiel, Fisher, and FNBC. The parties are not really debating the principles there, but they're obviously at odds as to how those work through into what's happened. Glover is tab 30, page 731 of the bundle, tab 30, page 731. That was the case that got this subset of the identification of consideration going. That was the case that dealt with the fruit machines, and it was a German case. And in fact, it was extremely easy and clear to identify what was the state money and what was the consideration, the taxable consideration, because there was a physical reserve box into which the state money went, and the only thing that the taxpayer could remove physically at the end of the day, or would remove, I should say, were what would be its taxable turnover. No doubt it also took the prize box money out for security reasons, but it replenished it every morning. So there wasn't the sort of debate that one might have had in other cases. The important paragraphs, time obviously is against me, so I will be concise. First of all, Advocate General Jacobs. I'm looking at page 735 of the bundle, 547 of the report, where the Learned Advocate General deals with question 1, which is the question as to what is the taxable turnover, at least in theory. And at paragraph 18, in a paragraph which is unfortunately too long for me to read, he speaks of the commercial reality being that which the trader earns, obviously, after deduction of certain cost components. And he says, I'll just read one sentence between G and H. As Glower and the UK observe, for all practical purposes, the operator's turnover consists in the amounts he's able to remove from the machine, and not in the total amounts inserted by the players. In the current case, the amounts that my clients can, as it were, put in their pockets were initially indicated as net on a by game basis, and then in 07 net of a per session basis. Of course, neither of those expresses the commercial reality of the business, which is net of the weekly, the monthly basis. But those are the two quite narrow focuses that we have, and we don't say either of them is wrong. staying with the Advocate General, and can I direct your Lordship's attention to paragraph 24 at the bottom of page 736 of the bundle, 548 of the case, where he says, in part, from the foregoing analysis, it follows that insofar as it's appropriate to charge VAT on gaming machine transactions, the taxable amount should be limited to the operator's actual takings, i.e., his net receipts after payment of winnings to the players. He then speaks about the player's viewpoint. Of course, in our case, people are playing against each other, and on one view, their view would be the game. And in the single multiple VAT analysis, the view of the reasonable customer is important. But as we've made or endeavored to make plain in our case, this is not a case which turns on single multiple analysis, and I don't believe that the Crown says anything to the contrary. Staying with the Advocate General for a moment longer, para 30 at the bottom of page 737, still on page 549, he said this: VAT is therefore charged at a uniform rate on each individual transaction. It's true that the proportion of each stake representing the price of the operator's services can only be determined by applying a percentage based on the average winnings paid out by a machine over a given period. I think that's the first time we see that familiar phrase. Carrying on. In practice, however, such a calculation is unnecessary. What is surely more important is that the taxable amount for a given period can be determined precisely on the basis of the sums removed by the operator from the cash box after replenishing the reserve. The view that the taxable amount consists of the total stakes inserted is open to the much more serious objection that in the case of many machines, the taxable amount itself would have to be estimated on the basis of average payouts. Now, unfortunately, that is the world we're in a case such as the present one, and we have moved from the payout per game basis to a payout per session basis, but as I've already indicated, neither of those really represents the commercial reality for the business. But so the glass bill was an easy case, though, because there was a cash box, there was a prize box, and there was a spatial geographical location which was replenished automatically. And therefore, but for establishing the principle, the case doesn't give one the tools to deal with, say, the bingo example with which we're concerned, which your lordships are concerned. The key part of the reasoning of the court lies on page 739 of the bundle, page 551 of the report. It's paragraphs 7 to 13. The court, as your lordships can see, at 7 refers to Article 11.3b, which is now Article 90. I won't read the words. In para 8, there's a reference to the intimately interconnected Article 11a1a, which is, of course, now para Article 93. It refers to the mechanics in para 9 and 10, it concludes, I won't read 11, 12, and 13, but essentially it easily concludes that which the operator can scoop out at the end of the day from the box, which isn't for the prize money, is what it can take. So that was an extremely simple case. My lords, then just moving to Fisher, which appears at tab 32, page 762 of the bundle, we move to roulette, and therefore somewhat closer to the current situation. GLAWA has established that one can take as a unit, as it were, multiple suppliers to multiple people over, say, a day, and work out a global figure for the taxable turnover. And in Fisher, once again, Advocate General Jacobs, the question was, will that analysis apply to a roulette game? And at page 769 of the bundle, 715 of the report, at para 33, the learned Advocate General, I just read one sentence, he says, The purpose of the National Court's question is to determine whether the court's ruling in Glawa concerning slot machine transactions applies to the roulette transactions in issue here, end of quote. And he concluded that it did in paragraphs 42 to 46. That's background reasoning. There isn't time for me to take your lordship through it. I apologize. The key paragraphs are at 49 and 53. This is still with the Advocate General. Unfortunately, there is only the Advocate General because the court decided the case on a different point. It didn't have to visit this question. But in my submission, this is very helpful to your lordships. At 49, just taking it up at the second line, the total of the amounts received by way of consideration for individual transactions corresponds to the organizer's net takings after payment of winnings during a given period. Over a period, the organizer's net takings necessarily correspond to the advantage which he reserves to himself. The fact that there is in practice an easier method of determining the taxable amount doesn't, however, mean that the tax isn't levied on individual transactions. I end the quote there. He rejects an observation made by the Commission. And then at the 53, he says this, the basic flaw in all of those analyses is that they produce a tax burden which isn't proportional to the organizer's real turnover. The essential reason for that is that a large part of the amount staked is repaid to players as winnings. It is treated as the organizer's turnover for that purposes. The result is an artificial inflation of his turnover. Such analyses ignore the fact that the nucleus of the gambling activity, although involving the use of money, doesn't involve the consumption of goods or services. So pausing there, that is the underlying approach. Of course, the wider the period or the longer the period of time that is taken, the more perfect that analysis will be. But that wasn't on the table, obviously, in this case. In bingo duty, as we observe somewhere, it's a 5-week period, but that's a different tax, a different time. Then if one doesn't turn to the judgment because the judgment doesn't deal with the issue. The final case moves us to First National Bank of Chicago. That is to be found at divider 34, page 797. And it's the same year, slightly later in that year as Fisher. And this is the case which applies the reasoning of those gaming cases to foreign exchange transactions. I have referred perhaps somewhat loosely to all of these as being money-for-money transactions. And that, of course, is one reason why perhaps there are difficulties for that system in dealing with it. If one looks at the judgment in the FNBC case, that is to say, at page 818 of the bundle, 871 of the report, the court reaches the second question. The first question was whether there was any supply at all. And this is one of those odd cases where it was the taxpayer that wanted a high turnover and the tax gatherers who wanted a low turnover, because they were dealing essentially with a type of transaction that generated no output tax, but did generate input tax recovery. It was a cross-border situation. So everyone was in a slightly different position from normal. That doesn't affect the principles. If one looks at the report, looking at page 818 of the bundle, 871 of the report itself, at paragraph 42, which I won't read aloud, that report refers to Article 11A1A, which is the basic rule, now Article 73. Perhaps skipping to 44, determining the consideration, therefore, comes down to determining what the bank receives for foreign exchange transactions. that is to say the remuneration on forex transactions, which it can actually take for itself. And there you see the point of contact with the Glauer-Spiel line of cases. I skip, if I may, in the interest of saving time, 45 and 46, which are rejected. And at 47 and 49, the court concludes, so the consideration, that is to say the amount which the bank can actually apply for its own use, regarded as consisting of the net result of its transactions over a given period of time. That important phrase appears. And then at 49, a very striking detail, nor is it necessary for either the taxable person supplying the goods or performing the service or the other party to the transaction to know the exact amount of the consideration serving as the taxable amount in order for it to be possible to tax a particular type of transaction. There's a reference to Argos. Consequently, it doesn't matter that when the transaction is concluded, the parties do not know the basis on which that will be charged, and that it remains unknown even afterwards to the recipient of the service. A striking but inevitable conclusion, given that unlike Lex and the mainstream, this is a quite unique area of VAT where the bargain struck between the parties does not define the tax outcome, and that is why, perhaps without turning it up, if I can say this, Lord Tyre at paragraph 80, in his opinion, it's page 246 of the bundle, accepted that there will be more than one right answer, or can be more, well, indeed, I think will be more than one right answer in such a case as this. And indeed, Lord Drummond Young at 70, para 70, page 240, he said that there is no right answer. I think what his lordship meant was there's more than one right answer, as it were. So they're obviously clearly wrong answers, but that, my lords, is the substratum of our contention that both the game basis and the session basis are correct. The way that feeds into the current debate, I can return for a moment to section 80, which, as your lordships will be aware, we say doesn't in fact have a role to play, is that, and the reason for that is that when my clients paid the original amount of VAT, they calculated it on the game basis. I've already indicated that we accept that that was one of the viable bases. And if I can briefly refer in support of that to one paragraph in the British Telecoms case, which is page 1509, it's tab 64, page 1509 of the bundle. Again, a case whose facts were very different, to do with another part of Article 11C, or Article 90 as it now is, the bad debt part of it, but at bundle page 1553, page 1970 of the report. This is the English Court of Appeal, paragraph 126. Lord Justice Reimer says this, speaking of the same provision. The upper tribunal's view, succinctly expressed at 181, was that section 80 applies to cases where the taxpayer has brought into account as output tax an amount that was not output tax due. When GMAC, and likewise BT, made its supplies, it accounted for tax which was then due. The subsequent failure of the customer to pay for the supply gave rise to a bad debt and a possible claim for bad debt relief, which would be for the repayment of all or part of the output tax originally paid by BT. The arising of such a bad debt did not, however, mean that the output tax earlier paid was not output tax due within the meaning of section 80. It was and remains so. The arising of the bad debt did not retrospectively change that. So, my lords, That reasoning is in respect of Article 90, as it now is, and a different part of the sentence. But we say, and it may be the commissioners agree, that that approach, that reasoning, means that Section 80 was not available to my clients to recoup what they freely paid with their eyes open at the invitation of the commissioners by way of the game-by-game basis. However, the review of matters, which took place in 2007 and thereafter, were such that matters were reopened, and the commissioners, as far as we know, do not suggest that they wrongfully paid out the 4 years' worth of output tax, which, by means of a retrospective calculation with reference to the revised basis, the revised formula, they accepted was within time, because by that stage, Section 80 time limit was, I think, 4 years. If, as we say, that this isn't a Section 80 case, we didn't pay him properly at the start, then what we have here is a case in which we're in the territory of the adjustment. I go back to the point I made right at the beginning with reference to Article 38, which effectively puts us, we say, in the same position as if, were this to be a purely contractual analysis, parties made a contract, they had a particular pricing formula, and your lordships will recall the use of the word formula in the public notices, both before and after the 2007 watershed. Parties had a contract, they had a formula, which from time to time led to a consideration. They then decide at some point to revisit the formula and, for prospective purposes, but acknowledge that retrospectively there can be an adjustment. And we say this case is no more complex than that, but the dialogue between the parties was reopened by the 2007 documentation. And we have been very kindly allowed through the door for the purposes of 4 years back. But there is, we say, no juridical analytical difference viewed with the benefit of the hindsight that we have today between years -1 to -4 and the earlier years, which are the years that are currently being debated. And this brings me back to the paragraphs 8.4 and 8.12.
Before we move on, Lord Hodge has a question for you.
I do apologise, I wasn't looking at my screen properly.
As you say, you were invoking Regulation 38. If I remember right, Regulation 38 requires the production of a credit note, and you've produced an internal credit note. Is that right?
We have.
And what is your view of the requirement? Is it Regulation 24? I can't remember where the requirement is for the credit note.
My lord, it is in Regulation 24. We deal with this in our case at paragraph 54 on page 125 of the bundle. Yes, and the background to the treatment that we propose there, as your lordship can see, is to be found in Mr. Justice Fields in an English case called GMAC, which is at tab 57, page 1339. It may be helpful to look at tab 57, page 1339. And I, of course, accept that we are trying to make a procedure which was enacted to deal with simple bilateral normal VAT transactions fit into a this globalized approach, this Garber-Spiel approach, which is your lordship saw a moment ago in FMBC, given that it's going to be multiple supplies to multiple people all being set off, it may well be that the customer never knows how much of, well, they won't, there's no may about it. The customer will not know, the punter, if I may use that word, will never know what element was the stake and what wasn't. So I frankly accept that one is trying to fit a piece of domestic anti-avoidance requirements, namely the credit note, which was designed for a bilateral, straightforward commercial transaction, into a somewhat different situation, within this case, at page 1355 of perhaps yes, 1355 of the bundle, para 38. Time really only permits me to show your lordships the conclusion. The Crown had argued for a different outcome. Mr. Justice Field supported the tribunal's practical outcome, and he sets out why it is acceptable to create effectively an internal document, as my clients have done here, and as was done by the General Motors company there, which at least performs the function of giving an audit trail to the representatives of the commissioners, as and when they interrogate the records of the taxpayers. So it's a practical consideration. It's a domestic. It must, in any view, give way to whatever we submit the right answer is in terms of the overall VAT analysis. But my lord, it does at least create a record that the commissioner's representatives can find, challenge, audit, and so forth. Given that we're dealing with these globalized, I haven't really made much of this, but I suspect it's entirely obvious to the court. This is one of the oddities of this corner of the VAT system, is that one's dealing with a globalized approach, and therefore, and usually high volume, low value transactions, which is a further aggravating factor. My lords, there is one passage in our case which deals with the fact that there is often more than one right answer. I only mention it to say that it refers to Majesty and Baldwin and my travel, which cases time does not permit me to deal with those. That's tab 35 and tab 40. This part of the case, which runs from para 76 to 88, I think your lordships can put on one side. I say that in a slightly hesitant tone of voice simply because I'm keen to hear what my learned friend says about the way we've invited your lordships to read, in his case, paras 8.4 and 8.12, which are the two ones I've already mentioned, where it would appear that the commissioners accept there is more than one way of doing this, and that the session-based or the game-based approaches have, at least in principle, equal validity. I maintain my point, as I've indicated, that Section 80 really has no role, and I should just remind the court that in Article 38, in Regulation 38, I believe I've read this for the court. Just let me, I may just find the reference again. Yes, I think I know I have. Regulation 38.7. I'm looking at a version of it on page 636. Says, none of the circumstances to which this regulation applies is to be regarded as giving rise to any application of regulations 34 and 35. I haven't shown your lordships those, but those are the error correction provisions. I think we've only got 34. 34 is to be found in the bundle at 631, and 34, at least where there is, so that's error correction, and that leads to a claim, and that takes us back to the language of the 2007 Commissioner's Notice, which I read to your lordships this morning. And what Regulation 34 does is therefore get back money which you should never pay in the first place. Regulation 35 we don't have, but it does roughly the same thing. Regulation 38, as you will be aware, deals with a different issue, which is where the goalposts have been moved. Normally, those will be goalposts moved in, quotes, the real commercial world. In this case, the real commercial world, for reasons that your lordships will understand, doesn't give us the answer, because the punter and the gambling supplier don't agree on a division. And so our short answer, therefore, to the real world point, I've been responding on that and I'm looking at the time, is that one has to compare apples with apples. And given that the only way, as it were, into the Article 73/90 machinery is through taking the game, taking the session, taking the week, whatever. Those are, number one, all equally valid. Certainly the game and session, we say, is equally valid, and I don't believe the commissioners are going to contradict that, but we'll find out in a moment. They're all equally valid, and if one is then going to apply Article 90 to see whether there has been a change, then one uses the same currency to test that, and doesn't, as the commissioners suggest, move to a so-called real-world basis, requiring, as they would, a refund of money, which wouldn't happen in any event. The parties have long since lost touch with each other, and that's exactly the case in the FNBC scenario as well, or an amendment to the terms of the contract, which the European Court makes plain is nowhere required in the legislation. So the central question is upon which in our submission the appeal turns, is whether it is appropriate to apply or to revisit the consideration on the basis of a different view of the facts, as would be the case, for example, not on the basis of a mistake as to what the facts were, that would be a different situation, but a different view of or presentation of the facts, which would be the same thing as if, for example, a commercial contract had a pricing formula that was then by agreement changed, and the parties agreed to apply the change retrospectively. In analytical terms, this is extremely similar. My lords, if I can just make the following short points, mindful of the time. That is a natural point, in a sense, for me to stop in any event. We go on. We go on to raise a number of other points. For example, the basis upon which, if it is contested, we can reopen this matter. And the Victoria and Albert case is mentioned. That's at tab 37, page 859. And in the same breath, there is the Gus merchandising case, which is tab 63, 1237. What both of those cases say is that it is entirely open to the commissioners to reach agreements, whether they're contracts or not, with taxpayers. And indeed, both sides rely on Victoria and Albert. The function of that point is is really exhausted if the parties are agreed that it is open to revisit through the ruling in 2007 to revisit what the situation is. And we say if that's right, then we did revisit it, and a fresh consensus was reached. Just returning, I'm just wrapping up some final points now, if your lordships would indulge me for just a few moments. Just returning to the fundamental question, the fact that money didn't change hands in this case was obviously a function of the fact that what has happened is that there has been a more generous redistribution between stake and profit within a fixed figure. And furthermore, the underlying provision, Article 90, does not require money to change hands. So that point taken by the commissioners is we say, beside the point. My lords, I dealt with the credit note point. I haven't dealt with, but I'm happy to stand on our case insofar as it deals with such matters as the Leeds Council point and related matters. We've set out our position in writing. If the commissioners stand by what, at least the reading that we propose of paras 8.4 and 8.12 of their case, we don't think those other matters arise because it will be a common ground that there are two valid approaches. One's based on game, other based on session. Commissioners have reopened the process in 2007 and very graciously permitted taxpayers to go back 4 years. They did so at a time, as I demonstrated this morning, where there was a 3/4 year time bar on going back either under Section 80 or indeed under Regulation 38. We now know Section 80 doesn't apply and Regulation 38 should never have had a time bar in the first place. So there is no juridical analytical difference, we say, between the claim in year -4, which has been paid, and the claim in year -5, 6 and 7 going back, which brings us to the court. The juridical basis for both is identical. My lords, those are our submissions. Unless I can assist the court further, I apologise for having overrun somewhat.
Thank you very much, Mr. Dyer. Mr. Thompson.
On behalf of commissioners, I invite the court to refuse the appeal and to adhere to the interlocutor of the First Division pronounced on the 13th of December 2018. In so moving the court, I would want to begin by outlining 5 key points, which in my submission run through a proper analysis of the issues raised by the present appeal. Point 1, the steps taken by the taxpayer after the supplies were made to reapportion the split between participation fees and stakes were not steps which fell within the scope of Article 90 of the Principal VAT Directive or domestically Regulation 38 of the 1995 regulations. 2, the terms of the various business briefs issued by the commissioners from time to time do not detract from that first proposition. There are 2 aspects to that point. First, the business briefs, although lawfully issued in the sense of being within the powers of the commissioners to issue them, did not themselves have the force of law. They rather represented the opinion of the commissioners as to how, in the particular case of the supply of bingo, the apportionment exercise ought to be carried out, so as to calculate the taxable consideration. Secondly, so far as Business Brief 0707 is concerned, even if, contrary to the Commissioner's submissions, it is held to have the status and effect attributed to it by the taxpayer, a proper consideration of its terms will show that it did not require the taxpayer to revisit its calculation of VAT for the period between 1996 and 2004. Point 3. Articles 73 and 90 of the Principal VAT Directive, although closely related, and although both reflect the principle of fiscal neutrality, are essentially concerned with fundamentally different issues. Article 73 is concerned with the identification of the taxable consideration for a supply, which is identified at the time the supply is made. Article 90, by contrast, is concerned with situations where, after the supply has been made, there is a reduction in the taxable consideration, or some or all of the consideration is not paid. As a matter of both authority and principle, the former does not include the latter. Point 4, and this follows from point 3, the taxpayer in the present case is wrong to characterise the process of identification of the taxable consideration as effectively being an ongoing process. In my submission, there are two separate exercises. First, the taxable consideration is identified at the time of supply. And in the ordinary case, this will be the subjective value, normally the contractually agreed sum. In a limited category of cases, however, such as gaming transactions, it is recognised that simply using the sum actually paid by a customer to a supplier would offend against the basic principle of VAT that the taxable amount cannot exceed the consideration actually paid by the final consumer. And that in such cases, the closest equivalent to taxable turnover will be the amount the supplier can keep for itself. That is, in the case of gaming transactions, the amount it retains after it's paid out winnings. Secondly, if after the supply has been made, the conditions set forth under Article 90 or domestically Regulation 38 are satisfied, the taxable amount may be reduced. In short, however, one in my submission cannot simply just reapply the Article 73 or Section 19 subsection 4 apportionment exercise after the supply has been made. The Article 90 Regulation 38 process is not just a revisitation afresh of the initial exercise. Rather, it is essential to appreciate that the relevant question, once the supply has been made and the consideration has been identified, is whether the criteria for the application of Article 90 or Regulation 38 are satisfied. Point 5, on a proper application of Article 90 and Regulation 38, they will only be engaged where there is what one might characterise as a real-world reduction in the sums received or retained by the supplier, either because it becomes or it receives less from its customer, or because it has made a payment back to another party in the supply chain. I have cause to return to these key propositions throughout the course of my submissions. However, having heard the submissions on behalf of the taxpayer, it may be helpful also to highlight and foreshadow the position of the Commissioners on some of the issues raised by my learned friends' submissions. The first of those concerns the approach taken by Lord Drummond-Young in the division in relation to the question of the meaning of the phrases price and consideration, and in particular the view offered by his lordship that a different meaning fell to be ascribed to price, where it appears in Article 90 of the Principal VAT Directive, as implemented in the UK by Regulation 38. The Commissioner's position is that they accept that, with reference to the Boehringer case to which my learned friend referred, the Court of Justice has confirmed that the phrases price and consideration at all times, for the purposes of Article 73 and 90, bear their normal VAT technical meaning. That is the extent of the concession, if it be a concession, that the Commissioners make in that respect. The Court, I hope, will have noted that it was not part of the Commissioner's argument before the Inner House, and nor is it part of the Commissioner's written case before this Court. That aspect of Lord Drummond-Young's reasoning was correct. Secondly, in the course of the learned friend's submissions, there was a discussion as to the appropriate methodology of apportionment, and in particular, whether the game or the session methods are both acceptable and lawful methods, or whether one or the other is correct. Now, my submission as to that matter is at the level of principle. At the level of principle, both are lawful. Neither Article 73 of the Directive nor domestically Section 19, subsection 4, cast in language that would provide a definite answer to that question of apportionment. But although in principle both might be lawful, in practice the answer in my submission would depend upon the nature of the supplies actually made by any given taxpayer. So if a taxpayer is in fact
Yes, I'm having some difficulty with this submission, I must say. You say neither Article 73 nor Article 90 give a definite answer, and I can see that if you just read the text of those provisions, it doesn't tell you clearly what's going to happen. But might it not be said that the Court of Justice and the Advocate General in Fisher have identified what the principle should be when you come to look at the way in which apportionment should be carried out, specifically to have it map as closely as may be the real world and the actual net receipts of the supplier, and that though that principle indicates that there is, in principle, in any particular case, a specific answer which will be right or wrong. Now, when I asked Mr. Cordara about this, he said, well, if there's a dispute, then the court decides. What's your position in relation to that?
in relation to that last specific matter, it is absolutely correct, and I accept that in the event of dispute, the court must decide. And indeed, this was the very point made by the Lord President at paragraph 27 of his opinion, which is at page 213 in the electronic bundle, that there would be an answer and the court would pronounce what the answer was if it was called upon to adjudicate. And I, of course, accept that that is correct. What I had about to go on to say was that while there is at the level of principle a possibility of a range of acceptable methods of apportionment, where a supplier is in fact making supplies on a specific basis, such as a supply of a session, then one sees that that would be the proper method of apportionment. And as to that, I was going to draw to the court's attention the VAT, the notice issued by the commissioners, which appears at page 446 of the bundle. This was the one issued in 2007, shortly after the business brief. At paragraph 3.2 on page 446, 46 under the heading, should I calculate the VAT on a game-by-game or on a session basis, says on the third line, as the players cannot participate in further sessions unless they make further payment, the supply to the players is completed when the session ends. If that is the nature of the supply, the passage at paragraph 3.2 correctly identifies in my submission when that supply comes to an end, and thus what the appropriate method of apportionment would be.
Am I understanding you correctly that you say in the circumstances of this case, there is in fact a single correct method of assessment, which is session by session?
So as to the precise nature of the supplies which this taxpayer made from time to time between 1996 and 2004, which is the period with which the present appeal is concerned, I am not for my part sure that the findings in fact made by the first tier tribunal allow one to know definitively what the nature of the supplies actually was throughout the whole of that period. But it is the case, as I think Lord Reid and the Chair identified earlier, that in the statement of facts and issues for the appeal before this court, paragraph 1, the parties have said that a unitary fee is paid for participation in a session. And if that be the case, if that is factually correct, then picking up on the terms of paragraph 3.2, that would be the appropriate method of apportionment.
Yes, thank you.
Wherein Article 90 territory or Article 73 territory, if the taxable supply is the supply of a session, then VAT, it seems, obviously has to be calculated on that basis. It's rather like paying for buying a season ticket at a Premiership football club or buying a season ticket at the Royal Opera House. You pay so many £100 and you will get a VAT receipt which showed the VAT on the season ticket. Rather than breaking it down into so many operas or performances or so many games of football and giving you a separate invoice for each one. So if the taxable supply is the session of a number of games of bingo, then you can't be given a VAT receipt at the moment you hand your money over at the door, because at that moment in time, it's not known what the element is of your payment that's going to be a stake in the games. But you could, in principle, be given a VAT receipt on your way out at the end of the session, because by that time, objectively, it will be ascertainable how much of your payment was actually used as a stake. And so you can calculate the VAT precisely. If, on the other hand, if the chargeable supply was a game, if you bought separate tickets for each individual game, then you would do the calculations on that footing and arrive at the correct answer. So whichever way you did it, you would arrive at an answer which was a correct answer, and the question of the consideration changing after the session had been, or game had been completed, wouldn't arise.
Lord, just to pick up on the session basis in the first instance, and the question of whether at that stage one would know what the VAT treatment ought to be for the session as between stakes and participation fees. My submission is that one would know at the start of the session what the appropriate apportionment was, and that's actually set out at paragraphs 4 and 6 of the Statement of Facts and Issues on page 90 of the electronic bundle.
Yep.
So paragraphs 4 and 6, that the manager decides after the sale of tickets so once the sale concludes, immediately before the session begins, what the prize will be and so on. So and that's a key aspect of the submission for the commissioners. That
Can you give the page reference again?
At page 98, my lord.
98. Right.
So it's page 98, paragraphs 4, 5 and 6 of the Statement of Facts.
Oh, yes, I see. Yes. So, and you can't. What I was trying to make was it can't be done at the moment when you buy your ticket at the ticket booth. You have to wait until everybody else has bought their tickets. But it's an ascertainable amount by the time the session ends.
It's an ascertainable amount by the time the session.
You say before it even begins.
Would,
Once everybody is present, everybody has bought their tickets, and the calculation has been done by the manager.
Exactly so. Exactly so. So at the reason I seek to put it in those terms, that at the level of principle, both methods may be acceptable, is dependent upon the nature of the supplies that are made, and recognising also possibilities. For example, in any given case, that a supplier might be admitting customers on different bases. So some customers, in theory, might be admitted on a game basis as compared to a session basis. But where we know, if we know the nature of the supply, and if we know it's a session basis supply, what's said at page 446 of the Commissioner's notice, paragraph 3.2 in my submission is correct, that after the players cannot participate when the session ends without paying further money. Sorry, my Lord Sales has a question.
I just want to be sure that I am understanding what you're saying here. At the moment, I'm understanding you're saying on the Statement of Facts and Issues that we've got here, the particular facts in this case, there was actually just one correct way of attributing between the stake and the participation fee, which is reflected in the post-2007 notices. You seem also to be saying, well, if the facts are different, you might have a different evaluative judgment about how one would apply the guidance in cases like Glaber-Spiel, Fisher and FNBC, which seems a statement of the obvious, that if the facts are different, an evaluation might be different. But in principle, there would still, in that different factual situation, be one correct evaluative judgment to be made. Have I understood you correctly, or are you saying something different from that?
No, I think my Lord has correctly identified my submission in this respect, and in relation to the factual position, as I mentioned to Lord Reid in the chair a moment ago in my submissions, there could be complicated factual situations where different customers are receiving supplies on a different basis that might open up the objective test required by Article 73 and Section 19, subsection 4, possibly to a range of answers. But if the facts simply are that the supply that is made is a supply of admission to a session, then for the reasons I've given, that is the correct basis in which to apportion.
Thank you.
And I'm ready to accept the observation that by saying that at the level of principle, different possibilities would exist if the facts were different. It may be a statement of the obvious, and I accept that, but that's what I mean when I say it's available at the level of principle. That was what I wanted to say at this stage in relation to the game against the session basis. The next point I wanted to pick up on from a learned friend's submissions, which follows on to some extent from the discussion about game and session apportionment, is the applicability of Section 80 to claims by this taxpayer or by other taxpayers who were making supplies of bingo. And the Commissioner's position in relation to that is set out at paragraphs 8.4 and 8.12 of their case. And there are a number of possibilities, plainly, in relation to Section 80. One could have the situation where more than one method of apportionment was possible. And if more than one method of apportionment is possible, and the taxpayer identified by way of epiphany that some other method may have produced a greater return to it, that would not give rise to a claim under Section 80, because for the reasons touched upon by the Lords earlier, the taxpayer would not in those circumstances have brought into account a sum of tax that was not due. If, on the other hand, there was only one right answer and the methodology adopted had been the wrong methodology, then it squarely fall within Section 80, subject to the constraints that are set out in that section. The position that the Commissioner set out at paragraph 8.12 of the case, building upon the case of Victoria and Albert Museum, is to say that the business brief may be seen misled taxpayers into thinking that there was only one valid method of apportionment and that it had to be the game basis, notwithstanding the nature of the supplies they were making. And if that were the case, that would give rise to an error of law, which, and I'll take the court to this in due course, in terms of Victoria and Albert Museum, would provide a basis for a claim under that provision. However, Section 80 in the present case is somewhat peripheral or tangential to the issues that are centrally in dispute. And the reason I say that is, first of all, even if the taxpayer did have a section, or did not have a Section 80 claim, that would say nothing about whether a Regulation 38 claim was or was not available. They are conceptually distinct in my submission. The second point, which is in my submission the point of importance concerning Section 80 in the present appeal, is that on a proper construction of the business brief, it was claimed under Section 80 in my submission that the Commissioners were inviting or referring to. I'll have to take the court to the business brief to make that proposition, why it is that that is, in my submission, a proper construction of the business brief. So even if they were wrong about that and a claim was not available, that is in fact what the Commissioners were doing. And they were not, in my submission, by contrast, either requiring a reapportionment under Regulation 38, Article 73, or inviting a reapportionment under Article 73 or Regulation 38. If they were doing anything, it was the invitation of a claim under Section 80. Now, having addressed those particular issues, oh, sorry, my Lord Sales has a question.
You're muted.
Yes.
Sorry, I didn't keep an eye on it. I'm sorry to press you on your paragraph 8.12 and section 80. And it links to the questions I was asking you before about whether there can be at the same time two correct answers. At the moment, if one's in a world where there can be two correct answers and the taxpayer chooses one of the correct answers, I'm struggling myself to see how Section 80 has any application, because the taxpayer will have paid what ex hypothesi was tax due. Yet you seem in your paragraph 8.12 to be saying that Section 80 would apply in such a situation. Can you just help us with what you mean by that?
The submission I make in relation to that, my Lord, is that notwithstanding it's being the Commissioner's position that the business brief did not have the force of law, in the sense that it did not do anything other than convey the opinion of the Commissioners as to the interpretation of the legislation as applied to this type of supply. Insofar as that document could be read and may have been read as indicating that the only way of apportioning was under the game method as opposed to a session methodology, that would have given rise to an error of law on the part of taxpayers, which in turn can provide the way into a Section 80 claim. But in all of this, I would wish to emphasise the point I made a moment ago, which is the present appeal, of course, is concerned with whether the taxpayer has a claim and is entitled to engage Regulation 38, and not whether it ever had a good claim under Section 80. And even if the commissioners were simply wrong to invite a claim under Section 80 in the business brief, in my submission, so be it. If they were wrong to do so, it would not affect the analysis in relation to Regulation 38.
Yes, thank you.
I'm really puzzled by this. Section 80 only applies in terms of subsection 1. We've got it in your case, actually, at paragraph 8.2. It only applies where a person has brought into account as output tax an amount that was not output tax due. So an error of law is only relevant if it results in the taxpayer doing that.
And I accept that that is so, my lord. It may be better if when I come in due course to take the court to Victoria and Albert Museum to explain how I seek to develop the error of law argument in that respect. But
yeah, I think it might be fair to say, Thompson, you seem to be seeing this case as being much more difficult than it seems to me, and it may be to others. I wonder if there may be ramifications of this point in a wider ramifications that the revenue may be concerned about. I just don't know. But so far as concerns the case before us, it seems pretty straightforward.
to the extent, maybe if I can find common ground with the observation my Lord has just made in this respect, to the extent that difficulties arise, they arise in understanding how a claim arises under Section 80 on the facts of this case. And I see that. But as I hope I've explained a moment ago, even if the commissioners were wrong to invite the possibility of claims under Section 80 in the business brief, in my submission makes no difference to the question of whether the taxpayer in the present case was entitled to invoke Article 73 or Article 90 or Regulation 38 in the way that it has sought to do. Because my essential submission as to these matters is that on no sensible analysis of Article 90 is what has happened here a price reduction or Regulation 38. And my submission, that is straightforward and simple, and it's somewhat obfuscated by the lengthy analysis undertaken by the taxpayer by trying to treat Article 73 and Article 90 as a continuum, effectively, which they are not, in my submission. But the complexities arise, I can well see, in understanding, could there be, was there a claim under Section 80? And for my part, I've sought to defend that analysis at paragraphs 8.4 and 8.12, because that commissioners in fact did. They issued the business brief inviting a claim, I say, under Section 80, and they have satisfied that claim under Section 80. And if there is a difficulty in this case, it's an understanding whether that was the right thing to do. But the difficulty does not concern Regulation 38, rather.
So far as we are informed by the statement of facts and issues, the basis of calculation, well, according to the statement of facts and issues, what were being supplied were sessions. Until the 2007 notice, calculations were being done widely on a per game basis. And if that's so, then it would follow that if we accept what you were saying earlier about how the calculation ought to be done, if the supply is in a session, it would follow that there were indeed valid claims that could be made under Section 80, because the per game basis would have overstated the true tax liability of the bingo operator.
Agreed. Yes. So if in circumstances where the suppliers of sessions to a portion on the gate basis would be wrong, it would bring into account tax that was not due, and the juridical route into a remedy is Section 80, and that excludes Regulation 38. So to that extent, Lord, I absolutely agree that complexities arise in trying to understand how Section 80 can be engaged if there's more than one correct answer. And I've explained already, that is what the Commissioners in fact did. And it maybe distracts from what is actually the central issue in the case in my submission, which is whether the facts set out in the Statement of Facts and Issues engage Regulation 38. Against all of that background, and still at the level of, in my submission, important principle that defines the approach the court ought to take to the issues which arise in this case, I wanted to turn to the important point that the particular category of transactions with which the present appeal is concerned is those which involve gaming or gambling transactions, which are seen as being part of a group encompassing foreign exchange transactions as well. These are effectively a specialised and unusual class of vatable supplies that bring with them their treatment. And in that connection, it is well established that such transactions, gaming transactions, foreign exchange transactions, are particularly ill suited to the application of VAT at all. And indeed, doubtless that is one of the reasons that bingo itself is no longer subject to VAT, as Mr. Cordara has alluded to already. And in that connection, I wanted just to give the court the reference to paragraph 30 in Freeman's against the Commissioners, which is at page 855 of the bundle, where the Court of Justice remarked that gambling transactions do not lend themselves easily to the application of VAT. So that's page 855. Paragraph 30. And the court goes on to observe that that being the case, it hardly appears appropriate to draw general conclusions from the taxation of such transactions. And following on from that, in my submission, it is likewise not appropriate effectively to ride roughshod over the fundamental principles of VAT in order to shoehorn the taxpayer's claim here into Regulation 38. To deploy Regulation 38 and Article 90 in the particular circumstances of this case to a purpose which they are not intended to meet in terms of the basic principles of VAT. That would be the tail wagging the dog. I wonder also, in the same respect, if I could just give the court the reference 11 from the opinion of the Advocate General in Glauspiel at page 734. And the point that's made in paragraph 11 there by the Advocate General is that if the member state has decided to exercise the option to impose VAT on the use of gaming machines, or in this case, gambling more generally, the tax imposed must conform to the basic community principles of VAT. That's the proper analysis, not the other way around, of distorting the fundamental principles to the unusual situation of VAT or gaming. The second point, by way of overview at this stage, I wanted to touch upon concerned the terms of the business brief itself, business brief 0707, and it's clear at at the urging of the taxpayer, that the first tier tribunal and the upper tribunal regarded the business brief as having mandatory effect and as of requiring the taxpayer not just prospectively but retrospectively to reapportion its VAT calculations. And that's seen perhaps most obviously in the judgment of the upper tribunal at page 273 of the electronic bundle. And it's paragraphs 57 to 59 of the judgment of the upper tribunal, but paragraph 58 in particular, that the emphatic change of language had retrospective effect and required the taxpayer to reapportion retrospectively. And there's that is advanced by the taxpayer in the tribunals below. In its case before this court, and in particular in the submissions, the oral submissions made by my learned friend this morning and this afternoon, he hasn't really, as I took his submissions, focused on this idea of a requirement being set out in the business brief, a requirement having the force of law. His emphasis has rather been upon it being an invitation, which was taken up by the taxpayer. It was an offer that was taken up, which is a rather different way of analysing the terms of the business brief than that which has been touched upon hitherto by the taxpayer. I wonder if I could take the court at this stage then to the business brief to draw attention to certain aspects of its work. It begins at page 451 of the electronic bundle. What the court will see under the heading background on page 451, in the second paragraph, on the second line of the second paragraph, it said that bingo promoters must work out how much of the payment is stake and how much is the participation session fee in order to determine how much VAT is due. Now that, of course, is the opinion of the commissioners expressed in that document, but it picks up in my submission on an important point. As I mentioned a moment ago, the taxpayer has sought to argue, at least in its written case and before the courts below, that the commissioners were duty to identify the given period over which the apportionment should take place. And it was argued specifically by the taxpayer that that is what the commissioners were doing when they issued the business briefs. They were in law fixing the given period, rather than the commissioners would have simply offering an opinion as to what the correct apportionment was against the legislative background of section 19 and article 73. The following paragraph explains why the brief was issued. It was in response to inquiries received by the commissioners from traders operating in this area. If one turns over to the following page under the heading Making Claims or Adjustments, the brief having set out the view of the commissioners as to how, going forward, taxpayers should carry out the apportionment. Under the heading of Making Claims, as the court have detected from the learned friend submissions, the taxpayer's position is that this was an invitation or a requirement to go back retrospectively and reapportion using the session method. My submission is that what we see on the second line is that it's taxpayers who now find they have used the game basis incorrectly. And this, I think, picks up on the exchanges I've had with my Lord and the Chair and Lord Sales about the circumstances in which Section 80 is engaged. Section 80 is engaged where tax has been brought into account that wasn't due. That is what this passage is discussing, the incorrect bringing into account of tax. And one sees that even more on the following line, resulting in an over-declaration of tax. And in my submission, that is a very clear indication that what the business brief was inviting was claims under Section 80. And of course, this was advice given by the commissioners at large rather than to a specific taxpayer. So not specifically to this taxpayer informed with the statement of facts and issues, in this case stating that the supplies were made on a session basis. So it's inviting taxpayers who incorrectly have used the game basis, producing an over-declaration to make a claim. Unashamedly, in my submission, the invitation of a claim under Section 80. I'll come back to the business brief later in these submissions, but my submission seeks to analyse the nature of the claim the taxpayer makes. And I think, to pick up on an observation my Lord Hodge made to Mr. Cordara earlier, what is the juridical basis upon which it is said that a claim arises? The answering of that question in my submission involves considering closely the terms of the business brief, because whether it's characterised by the taxpayer now as an invitation to do something or a requirement to do something, one has to understand what it was that was being invited or required. In my submission, very clearly what was being invited was the making of claims by taxpayers who had brought into account tax that was not due, not a retrospective reapportionment of the Article 73 consideration. Lord Hodge, yes.
It was really those passages I had in mind when I was asking the question, because they seem to me to be dealing with Section 80. And if one were to treat it as a wider invitation, where on the hypothesis that the previous arrangement was perfectly legal, what I was trying to explore is what power did the revenue have to waive tax which had lawfully been assessed and obtained?
And the answer, of course, is they have not got that power, and I would suggest otherwise. But before leaving that document, it's also worth noting there's provision about how the claims might be progressed. Claims under £2,000 dealt with an adjustment in the current return. Where they're more than that, they have to be subject to a claim. I'm going to take the court to the regulations that bear upon that. That's about Section 80 again. And next, and this, in my submission, could not make it any clearer, there's reference to unjust enrichment, that the claim may be rejected if it would produce unjust enrichment. That, again, is only about Section 80 of the Act and has nothing to do with Regulation 38. So
there is no unjust enrichment defence, as it were, in Regulation 38, because there's no error, and it's the error that gives rise to the restitutionary right, and the restitutionary right is restricted by a defence, as it were, of unjust enrichment.
Indeed, and there may be a broader coalescing of these principles at this stage, my Lord, in this sense that the reason, or one of the reasons there is an unjust enrichment defence under Section 8 is that if none of that money has made its way back to a customer, that the taxpayer will be unjustly enriched if it's just produced a claim for its own benefit. Par excellence, that is what the taxpayer is doing here. It is trying to produce a situation where it and it alone benefits, with no change in its relationship with its customer at all.
That's one of the oddities of this claim, relying as it does on the principle of neutrality. But the one person whose financial position will not be altered, of course, is the punter who has paid the VAT inclusive sum.
Exactly so, Lord. And in that respect, if I can, I've touched upon already the difficulty in distorting, or the inappropriateness of distorting basic principles of VAT to accommodate the particular nature of this transaction. And when on that theme, when the taxpayer complains that the analysis offered by the commissioners makes it impossible or unduly difficult for it to satisfy the requirements of Regulation 38, for example, credit notes that actually involve the customer and involve money going back, that in truth, in my submission, simply a reflection of the nature of the supplies that this taxpayer is making, the nature of its business, that it is extremely unlikely that where the punter comes along, pays his or her money to participate in a session and leaves the hall at the end of the day, it's very difficult in the ordinary run of things to envisage circumstances where Article 90 will ever be engaged in that type of activity. That's just the truth of it. And that's not making it disproportionately difficult for the taxpayer to exercise its directly effective rights. It's merely recognising that that's the business the taxpayer is in fact in. I wanted to turn then to the interrelationship between Articles 73 and Article 90. And as the court will have seen from the written case for the taxpayer, considerable time is spent developing the argument that Article 73 and Article 90 have as their essential aim the same thing, and that this is a continuous process that must be gone through to identify and almost keep under review the Article 73 taxable consideration. Now that point is starkly seen, my lords, if one goes to page 127 of the electronic bundle, paragraph 58 of the taxpayer's case. This is where the taxpayer offers its interim conclusions in relation to Article 73 and Article 90. The fourth proposition at paragraph 58, all of this is to be done in the course of the proper application of Article 73. The requirement to correctly fix upon a neutral sum by way of the taxable turnover does not stop at the time of the original supply. It continues at the time of supply to deal with any changes in consideration from any cause, particularly those ejusdem generis, with the basis of the original ascertainment of the taxable amount. Articles 73 and 90 go hand in hand, working at all times to achieve an overall answer to the ascertainment of the taxable turnover of suppliers, including in connection with the gaming industry. Now that view of Article 73 and Article 90 is, in my submission, essentially founded upon the reliance that the taxpayer places upon Elida Gibbs and the judgment of the Court of Justice in that case. And I'll take the court to that case in due course. Before analysing that and some of the related authorities, there are 2 points that should be noted at this stage. The first is that in offering this thesis that Articles 73 and Article 90 operate together in the way that the taxpayer suggests, all of the authorities the taxpayer relies upon in that connection are Article 73 cases, with the potential exception of Elida Gibbs, which I'll treat separately. But all of the cases founded upon to support that argument are Article 73 cases. And just to give the court the references to each of those cases where one can see that what was being discussed by the Court of Justice was Article 73. First of all, in Glauspiel, at page 740 of the bundle, paragraph 13. Secondly, International Bingo, at page 995 of the bundle. That's paragraph 33. Thirdly, Fisher, which is page 711 of the bundle, paragraph 12, subparagraph 2. And finally, First National Bank of Chicago, page 819 of the bundle, paragraph 50. These are all cases concerned with the Article 73 exercise, the ascertainment of the taxable amount at the time the supply is made. The other side of that coin, the second point I seek to make, is that in its written case, the taxpayer seeks to dismiss effectively as irrelevant the cases relied upon by the commissioners which do actually concern Article 90 or Article 11C, namely Goldsmiths and Freemans. And so the court has the reference to a summary of the taxpayer's dismissal of those cases. That's paragraphs 59 and 60 of the taxpayer's case, electronic pages 127 to 128. So these cases are effectively treated as not relevant, even though they actually concern Article 90, unlike the cases founded upon by the taxpayer. And so at page 128, paragraph 61, the taxpayer says of these cases, neither case involved a Glauspiel type valuation process. Accordingly, a bad debt case and a deferred refund case throw little useful light on the issue. First National Bank, which very much did address the current issue, was held to have no direct bearing on the matter at hand. Now, given that argument and the weight the taxpayer places upon Elida Gibbs, there are 3 points to note here. The first is, as is obvious, Elida Gibbs does not involve a Glauspiel type valuation process. Secondly, Elida Gibbs is a deferred refund case, and on the basis of the taxpayer's own argument at paragraph 61, that is the basis on which it dismisses cases such as Goldsmiths and Freemans as being not relevant. Thirdly, First National Bank, the case that the taxpayer says very much did address the current issue, as I've indicated already, is an Article 73 case. It's not an Article 90 case. So with that background, one turns, in my submission, properly forearmed, as it were, to understand what the court was and was not deciding in Elida Gibbs and the weight that should be given to Elida Gibbs in this court's consideration of the appeal before it. And the questions that were before the Court of Justice in Elida Gibbs are set out at page 757 of the electronic bundle, paragraph 2. And what the court will see, looking at paragraph 2, is that the question that was framed by the referring court in its own terms ran together Articles 11A and 11C. So paragraph 2 on page 757, the question from the referring court ran the two articles together and did not discriminate between them. When one moves on to paragraph 28 of the court's judgment at page 758, the principle that is stated there is set out at a high level, in my submission, a high level of generality with reference to conformity with the directive. That's at letter H around the middle of that paragraph. So the principle here being discussed is conformity with the directive, rather than specifically with reference to any Article 11A or 11C. Paragraph 29, still on the same page, the court's conclusion that the taxable amount attributable to the manufacturer is the amount corresponding to the price at which they sold the goods to the wholesalers or retailers less the value of the coupons, is again does not indicate whether the court is treating of Article 11A or 11C at that stage. It is, however, that at paragraph 30 the court then says that that interpretation is borne out by Article 11C, and the Lords had their attention drawn to that by Mr. Cordara already. At paragraph 31, there is a discussion of the paradigm case in which Article 11C will be engaged. And in that paragraph, paragraph 31, what the court in my submission is saying is that reduction of the taxable amount under Article 11C, or now Article 90, is provided for to ensure observance with the principle of neutrality. And it's in that respect that Article 90 and Article 73 are related, that they both have as their aim observation of the principle of neutrality. I have to recognise, so far as it goes, that at paragraphs 34 and 35 of the judgment, reflecting, as I've sought to show the court, reflecting the general question that was put by the referring court, the Court of Justice does answer the question posed by running together Articles 11A and 11C. That, however, is the high point in my submission of the taxpayer's argument that Article 73 and Article 90, or 11A and 11C, as previously was the case, effectively fall to be treated as the same and aimed at the same purpose or being engaged in the same circumstances. In my submission, however, the analysis does not end, as it was rather left by the taxpayer with Elida Gibbs. The other one has the benefit of subsequent cases from the Court of Justice. The next of which is Freeman's, at page 844 of the electronic bundle. And for the sake of time, I hope I can just give the court the references to paragraphs 24 to 29 in the judgment of the Court of Justice in Freeman's. And what emerges in Freeman's is the court's conclusion that the discounting scheme could not be used to support the idea that from the outset, in other words, in Article 73 terms, the taxable consideration failed to be calculated taking into account the discount, but rather it was in Article 90, Article 11C as was, terms, that the discount failed to be taken into account as a price reduction when it was actually given effect to. It's at paragraph 30, I should also say, on page 849. Sorry, 30 of the judgment of the court, rather, at page 855, that the passage appears to which I referred earlier, my lords, about the special nature of gaming transactions and the caution that should be exercised in deriving general principles from cases involving gaming transactions. However, that analysis in Freeman's that involves recognising that it's Article 11C or Article 90 that is engaged in a way that the court did not pin itself down to in Elida Gibbs. That analysis in Freeman's is, in my submission, put beyond doubt by the case of Grattan and the commissioners. It's referred to extensively in the case for the commissioners. And if I could ask my lords to turn up page 968 of the electronic bundle, that is where that case is to be found. And if one goes to page 975, paragraph 25 of the judgment of the, sorry, referring mistakenly to the Advocate General. If we go to the court at paragraph 25, which is on page 984 of the electronic bundle. The point which the court identifies is going back to the second directive, part of the case that was before the Court of Justice, part of the relevant period of time was governed by the second directive. But the second directive did not have in it an equivalent of Article 11C or Article 90. It only had an Article 11A or Article 73 type provision. That is what the court recognises at paragraph 25. And at paragraph 27, on page 985, the Court of Justice says, neither Article 8A, for which now read Article 73, or any other article of the second directive could be interpreted as meaning that regularisation of the basis of assessment or of the output tax after delivery, which is when the chargeable event took place, had to be permitted. Paragraphs 28 and 29 contain a helpful discussion of fiscal neutrality. It may be recalled that in the taxpayer's written case, very considerable weight is placed upon the operation of fiscal neutrality in its analysis. Paragraphs 28 and 29 in my submission help in understanding, as a general principle, fiscal neutrality will not assist with an Article 90 type argument. It won't make up for the absence of Article 90, if I can put it in those terms. And it did not make up for the absence of an Article 90 provision in the second directive. The court's conclusion is set out at paragraph 37 at page 986. The answer to the question referred must be that Article 8A, as I've said, that's the equivalent of 73 now, must be interpreted as not conferring upon a taxable person the right to treat the basis of assessment of a supply as retrospectively reduced, where after the time of that supply of goods, an agent received a credit from the supplier which the agent elected to take either as a payment of money or as a credit against amounts owed to the supplier in respect of supplies of goods that had already taken place. And indeed, paragraph 36 makes the point that Article 11C, now 90, is not inherent in Article 11A or Article 73. So in my submission, the treatment of these issues by the Court of Justice in Grattan supports the contention of the Commissioners that although Articles 73 and 90 are linked in the sense that they both have as their ultimate aim the observance of the basic principles of VAT, including fiscal neutrality, when one is dealing with the post-supply reduction in consideration, the article and the only article that can give effect to that is Article 90. And that article is given effect to domestically in the United Kingdom by Regulation 38 of the 1995 regulations. And in my submission, that helps to explain why the analysis of the taxpayer, heavily founded as it is upon Elida Gibbs, that the Article 73 process is an ongoing one of review, is ill-founded. The proper approach in my submission is that it's Article 90, domestically Regulation 38, that governs, but in order to bring oneself within the scope of Article 90 and Regulation 38, one must actually satisfy the specific conditions that attach to Article 90 and Regulation 38, which are not merely a recapitulation, as the taxpayer would have it, of Article 73. And critically, the Commissioner's submission is there has to be this real-world reduction in what the taxpayer can retain for itself. What it has actually received has to go down. Touching still upon the question of fiscal neutrality, if I could simply give, my Lords, the reference in the judgment of Lord Walker in the case of Lex and the Commissioners, paragraphs 26 and 27, which appear at electronic page 1094 to 1095. There is a discussion there of the significance of the principle of fiscal as a general principle, as a residual principle that does not have the central and dynamic effect that the taxpayer seeks to suggest it does in its written case. And at this point, my Lords, in the analysis, picking up on the importance and the limitations of fiscal neutrality, that principle, of course, goes hand in hand with a number of other European law principles, one of which is the principle of certainty. And in that respect, in my submission, one can see the force of the observation made by Lord Drummond Young in the Inner House at paragraph 68. That That's to be found at page 239 of the electronic bundle. His Lordship is here discussing the differing nature and purpose of Regulation 38 on the one hand and Section 80 on the other. So His Lordship offers the view that Regulation 38 is of relatively limited scope and that conclusion is supported by the legislative context. By contrast, Section 80 provides a general power to adjust VAT liabilities in the light of factors such as errors in calculating VAT or subsequent changes of circumstances. And the 4-year limitation in the domestic law is then referred to, as is 7 lines in the defence of unjust enrichment. What His Lordship goes on to say in my submission of importance is this. In this context, it is in my opinion very obvious that Regulation 38 is intended to serve the limited function of adjustments for increases or decreases in consideration that had actually taken place as between a taxable supplier and its customers. Moreover, such an opinion, in my opinion, is clearly supported by the case law of the Court of Justice. He refers to the real commercial world and changes in obligations and liabilities. And the broad point that His Lordship makes there and at other passages in his opinion, picking up in particular about the limit period in respect of Section 80 claims, is that in implement of the principle of certainty, tax liabilities must be definitively assessed within a restricted period to ensure finality and to protect the national revenue from unanticipated claims. That is why when a broad provision is enacted allowing over-calculated tax to be refunded, that it's subject to domestic limitations. And that is likewise why on the other side of that coin, such limitations would not inhere in a real-world commercial change, which is what Article 90 and Regulation 38 are concerned with. In relation to this broad issue of the interrelationship between Article 73 and Article 90, the taxpayer argues, Lords, at paragraphs 7 and 9 of its written case, which is electronic page 109 to 110, that the First Division erred in not mentioning the direct effect of Article 73 and Article 90 and in not giving any consideration, as it puts it, to the question of whether Article 73 might be available to plug the gap if Article 90 and Regulation 38 were found not to be engaged. So we see again the taxpayer is suggesting that even if it cannot satisfy the criteria for the proper engagement of Article 90, Regulation 38, Article 73 comes in to plug the gap. And in my submission, first of all, the First Division did not overlook Article 73. It properly gave it its place, and it was not an article that was engaged in the circumstances of this case after the supplies had been made. And secondly, the Inner House was correct in that respect, precisely for the reasons which I have been touching upon already in submission. The taxpayer, on that basis, my Lords, goes on, and this was touched upon by my friend this morning, it goes on at paragraph 13 rather, of its case, page 111 of the electronic bundle, to argue that the Inner House's approach, which gave effect in this respect to the argument of the Commissioners, makes no provision for increases or decreases in deemed consideration arrived at on Glauspiel principles. And a similar point is made at paragraphs 63 to 65 of the taxpayer's case, electronic pages 129 to 130. Lord, it's my submission that these points are not well founded. It's not disputed, and the Commissioners do not dispute, that in Alida Gibbs and indeed in Freeman's, the Court of Justice held that Article 90 does not require a change to the contract terms. So, for example, the price reduction might arise by giving effect to the contract terms. But a change in the contract terms is not required. But it is also not the and it's not the effect of the Commissioner's argument or the approach which the First Division of the Inner House took, that it is thereby impossible for there to be a reduction in a deemed consideration. Rather, the Commissioner's point simply is this: such a reduction does not arise simply by deploying a different formula. The circumstances in which a deemed consideration might be reduced, pursuant to Article 90 and Regulation 38, is if the data which is fed in to the formula changed. So if the real world data changed, then that might in principle give rise to a reduction in price or a reduction in consideration. But this is, in my submission, largely back to the point I had made earlier in my submissions, that the reality in this case, and why it is in truth, in my submission, indeed a straightforward case, the reality in this case is that the difficulties arise simply because in transactions of this sort, it is very unlikely there will ever be an Article 90 price reduction. And what one should not do is distort that principle in order to accommodate something that is not a price reduction properly understood under Articles 90 and Regulation 38. Lords, I'm about to turn to a different issue. I'm conscious it's 4 minutes to 4. I'm happy to carry on for 4 minutes or adjourn now if that's the court's preference. I fear Lord Reid is muted.
So sorry, am I audible now? Since we've reached a convenient point, we'll adjourn now and resume at 10:30 tomorrow morning.